the urgent needs of our fellow citizens. We can do it. I believe we will. We can't sit here and just talk. We have to do it now. Mr. President, I see my friend from Iowa on the floor, and I yield the floor.
President,
The senior senator from Iowa is recognized.
I would ask that the remarks that I make follow Senator Sessions' remark.
Without objection.
Yeah.
So ordered.
I rise to rebut the points that Senator Sessions has made. And I do acknowledge, as he said on the floor, that 2 or more years ago, I was on the same page he was on this issue. So what has intervened in the meantime that causes me to differ from the position that Senator Sessions has taken? Well, it is a district court case giving justice to a company that, as one client, justice to a company that was denied that sort of justice because bureaucrats were acting in an arbitrary and capricious way. So Senator Sessions makes the point that you get equal justice under the law from the judicial branch of government, and that Congress should not try to override that sort of situation. Well, Congress isn't overriding with the language in the House bill that he wants to strike, because that interest was satisfied by a judge's decision saying that a particular entity was denied equal justice under the law because a bureaucrat making a decision on just exactly what counts as 60 days was acting in an arbitrary and capricious way. So this language in the House bill has nothing to do with helping a special interest, because that special interest was satisfied by a judge that said an entity was denied equal justice under the law because a bureaucrat was acting in an arbitrary and capricious manner. So this amendment is not about a special interest. This amendment is about uniformity of law throughout the country, because it's wrong for, as the judge says, for a bureaucracy to have one sort of definition of when 60 days begins. If it's after business hours, if something goes out, or if something coming in, it includes the day that it comes in. So we're talking about how do you count 60 days? And it's about making sure that there's a uniform standard for that based upon law passed by Congress and not upon one judge's decision that applies to one specific case. And I would say, since this case has been decided, there are at least 3 other entities that have made application to the Patent Office to make sure that they would get equal justice under the law the same way as the entity that got help through the initial decision of the judge. So this is not about special relief for one company. This is about what is a business day, and having a uniform definition in the law of the United States of what a business day is, not based upon one district court decision that may not be applied uniformly around our nation. So it's about uniformity. not about some bailout, as Senator Sessions says. It's not about some ferocious lobbying effort, as Senator Sessions has said. It's not just because one person was 1 hour late or 1 day late, because how do you know whether they're 1 hour late or 1 day late? If there's a different definition under one circumstance of when 60 days starts and another definition under other circumstances when a 60-day period tolls. And also I would suggest to Senator Sessions that this is not Congress interfering in court cases under appeal, because the government lost this case and the government is not appealing. Now, there might be some other entity appealing for their own selfish interests to take advantage of something that's very unique to them. But just in case we have short memories, I would remind my colleagues that Congress does sometimes interject itself in appeal process. And I would suggest that one time that we did that very recently, maybe 6 years ago, and that may not be very recent, but it's not like we never do it, and that was the Protection of Lawful Commerce Act of 2005, when Congress interjected itself into issue to protect gun manufacturers from pending lawsuits, and it happens that 81 senators supported that particular effort to interject ourselves into a lawsuit. So, Mr. President, in a more formal way, I want to repeat some of the things that I said last summer when I came to the Senate floor and suggested to the House of Representatives that I would appreciate very much if they would put into the statutes of the United States a uniform definition of a business day and not leave it up to a court to maybe set that standard so that it might not be applied uniformly. And secondly, to make sure that it was done in a way that was treating everybody the same, so everybody gets equal justice under the law, and they know what the law is, and they don't have to rely upon maybe some court decision in one part of the country that maybe they can argue in another part of the country, and also to tell bureaucrats, as the judge said, that you can't act in an arbitrary and capricious way, but bureaucrats might act in an arbitrary and capricious way, in a way unknown to them, if we don't have a uniform definition of what a business day is. So I oppose the effort to strike Section 37 from the Patent Reform Bill for the reasons I've just given, but also for the reasons that are already expounded by the chairman of this committee, that at this late date, after 6 years of trying to get a patent reform bill, and we haven't had a patent reform bill for decades, and it's badly needed, that we shouldn't jeopardize the possible passage of this bill to the President of the United States for his signature by sending it to the other body and perhaps putting it in jeopardy. But most importantly, I think we ought to have a clear signal of what is a business day, a definition of it. And this legislation in Section 37 makes that very clear. During this past June, I addressed this issue in a floor statement, and I want to quote from that, because I wanted my colleagues to understand why I hoped the House-passed bill would contain Section 37 that was not in our Senate bill, but was passed out of the House Judiciary Committee unanimously. And speaking as ranking member of the Senate Judiciary Committee, now and back in June when I spoke, I wanted the House Judiciary Committee to know that several Republicans and Democratic senators had asked me to support this provision as well. Section 37 resulted from a recent federal court case that had its genesis the difficulty that the FDA, the Food and Drug Administration, and the Patent Office face when deciding how to calculate Hatch-Waxman deadlines. The Hatch-Waxman law of the 1980s was a compromise between drug patent holders and the generic manufacturers. Under the Waxman-Hatch law, once a patent holder obtains market approval, the patent holder has 60 days to request the Patent Office to restore the patent terms. Time lost because the FDA's long deliberating process eating up valuable patent rights. The citation to the case that I'm referring to is in 731 Federal Supplement 2nd, 470. The court found, and I want to quote more extensively than I did back in June. This is what the judge said about bureaucrats acting in an arbitrary and capricious way. And when does the 60 days start? Quote, the Food and Drug Administration treats submissions to the FDA received after its normal business hours differently than it treats communications from the agency after normal business hours. The government, I'm continuing to quote from the decision, the government does not deny that when notice of FDA approval is sent after normal business hours, the combination of the Patent Trademark Office's calendar day interpretation and its new counting method effectively deprives applicants of a portion of 60-day filing period that Congress expressly granted them. Under the PTO's interpretation, the date stamped on the FDA approval letter starts the 60-day period for filing an application, even if the Food and Drug Administration never sends the letter. An applicant could lose a substantial portion, if not all, of its time for filing the patent trademark extension application as a result of mistakes beyond its control. An interpretation that imposes such drastic consequences when the government errs could not be what Congress intended. So the judge is kind of telling us in the Congress of the United States we could not have intended ever, but because we weren't precise, it gives question marks behind it of when 60 days starts to toll. And the question then is, if it's treated one way for one person and another way for another person, or one agency treats it one way and another agency treats it another way, is that equal justice under the law? And I think it's very clear that the judge said it was not. So I say the judge was correct. Congress certainly should not expect nor allow mistakes by the bureaucracy to upend the rights and provisions included in the Hatch-Waxman Act or any other piece of legislation that we might pass. The court ruled that when the Food and Drug Administration sent a notice of approval after business hours, the 60-day period requesting patent storage restoration begins the next business day. It's as simple as that. The House, by including Section 37, takes the court case where common sense dictates to protect all patent holders against losing patent extensions as a result of confused counting calculations. Regrettably, misunderstandings about this provision have persisted. And I think you hear some of those misunderstandings in the statement by Senator Sessions. This provision does not apply to just one company. The truth is, it applies to all patent holders seeking to restore the patent term time lost during FDA deliberations. In other words, allowing what Hatch-Waxman tries to accomplish, justice for everybody. In recent weeks, it has been revealed that already 3 companies covering 4 drug patents will benefit by correcting the government's mistake. It does not cost the taxpayers money. The Congressional Budget Office determined that it is budget neutral. And this piece of legislation, or Section 37, has been pointed out as maybe being anti-consumer, but it is anything but anti-consumer. I would quote Jim Martin, chairman of the 60 Plus Association. He said, and I quote, "We simply can't allow bureaucratic inconsistencies to stand in the way of cutting-edge medical research that is so important to the increasing number of Americans over the age 60. This provision is a common-sense response to a problem that unnecessarily has ensnared far too many pharmaceutical companies and caused inexcusable delays in drug innovations." And we have also heard from prominent doctors from throughout the United States. They wrote to us stating that Section 37, and I want to quote there, is, begin quote, "is critically important to medicine and patients. In one case alone, the health and lives of millions of Americans who suffer from vascular disease are at stake. Lives are literally at stake. A vote against this provision will delay our patients' access to cutting-edge discoveries and treatments. We urgently request your help in preserving Section 37. So, end of quote. So, Mr. President, Section 37 improves our patent system fairness through certainty and clarity, and I urge my colleagues to join me in voting to preserve this important provision as an end in itself, but also to make sure that we do not send this bill back to the House of Representatives, but get it to the President, particularly on a day like today when the President is going to be speaking to us tonight about jobs. And I think having an updated patent law will help invention, innovation, research, and everything that adds value to what we do in America and preserve America's greatness in invention and through the advancement of science. Maybe in conclusion, I would say that it's very clear to me that the court concluded that the Patent Trademark Office and not some company or its lawyers had erred, as is the implication here. A consistent interpretation ought to apply to all patent holders in all cases, and we need to resolve any uncertainty that persists despite the court's decision. I yield the floor.
Senior Senator from Vermont is recognized.
Mr. President, I thank the distinguished senator from Iowa for his words. You know, this, and I join with the senator from Iowa in opposing the amendment for two reasons. First, and just simply practical matter, the amendment would have the effect, if it passed, of killing the bill, because it is not going to be accepted in the other body. And after 6 years or more of work on patent bill, it's gone. But also on just the merits of it, the provision that this amendment strikes, Section 37 of H.R. 1249, simply adopts the holding of a recent district court decision codifying existing law about how the Patent and Trademark Office should calculate filing dates for the purpose of considering a patent term extension. So those are the reasons why I oppose the amendment to strike it. The underlying provision was adopted by the House as a bipartisan amendment on the floor. It was offered by Mr. Conyers and had the support of Ms. Pelosi and Mr. Berman on the Democratic side, and had the support of Mr. Cantor, Mr. Paul, Ms. Bachmann on the Republican side. I have a very hard time thinking of a wider range of bipartisan support than that. And the provision is simply about how to calculate filing dates for patent term extensions, though its critics have labeled it as something a lot more. A patent holder on a drug is entitled by statute to apply for an extension of its patent term to compensate for any delay that the Food and Drug Administration approval process caused and actually bring the drug to market. Now, the patent holder has to file that application for extension within 60 days, beginning on the date the product received permission for marketing. But there is some ambiguity as to when the date is that starts the clock running. Now, only in Washington, D.C. could this system produce such absurd results that the word date means not only something different between two agencies, the PTO and the FDA, but then is given two different constructions by the FDA. Now, if this sounds kind of esoteric, Madam President, it is. And I've been working on this thing for years, and it is difficult to understand, but the courts have codified it, and let's not go and try to change it yet again. What happens is the FDA treats submissions to it after normal hours as being received the next business day. But the data submissions from the FDA are not considered the next business day, even if sent after hours. To complicate matters, the PTO recently changed its own method of defining what is a date. This sounds confusing. Even in Washington, you can imagine how it is outside of the bureaucracy. Confusion over what constitutes a date for purposes of a patent extension has affected several companies. Now, the most notable case involves the medicines company's Angiomax extension application request. Now, the PTO, after Medco challenged the PTO's decision in court, after the extension application was denied by the PTO because of the difference in the dates, Medco challenged that. And last August, the Federal District Court in Virginia held the PTO's decision arbitrary and capricious, and Medco received its patent term extension. Now, just so you fully understand what that means, it means the PTO now abides by the court's ruling and applies a sensible business day interpretation of the word date in the statute. The provision in the America Invents Act simply codifies that. Senator Grassley has spoken to this, and as he said a few weeks ago, this provision improves our patent system fairness through certainty and clarity. Now, the issue has been around for several years, and it was a controversial issue. We all accept that. When it would have overturned the PTO's decision legislatively. For this reason, Senator Grassley and others opposed this provision when it came up several years ago. But now that the court has ruled, it's a different situation. The PTO has agreed to accept the court's decision. provision is simply a codification of current law, and those who might have disagreed before say, okay, the court's ruled, we accept the court. Madam President, I've, previous life, argued a lot of cases in my state before our Court of Appeals, the Second Circuit Court of Appeals, argued both federal and state courts. When you have a court decision, you go by that court decision. That's what Senator Grassley and I are doing. Is there anyone who truly believes it makes sense for the word date to receive tortured and different interpretations by different parts of our government rather than to have a clear, consistent definition? It's actually time to put this issue to bed once and for all. Now, the provision may solidify Medco's patent term extension, but it applies generally, not just to this one company as has been suggested. It's going to bring common sense to the entire filing system. If the Senate adopted the amendment, however, the Senator from Alabama, it'll lead to a real conflict with the House. It's going to complicate, delay, probably end passage of this important bipartisan jobs-creating legislation. Keep in mind, Madam President, yesterday I said on the floor that each one of us in this body could write a slightly different patent bill. We don't pass 100 bills. We pass one. This bill is supported by both Republicans and Democrats across the political spectrum. People have been working on this issue for years and years. The same thing in the other body. People on both sides of the aisle have worked on this for years. We have a piece of legislation. Does everybody get every single thing they want? Of course not. Madam President, I'm chairman of the Senate Judiciary Committee. I don't have everything in this bill I want, but I've tried to get something that is a consensus of the large majority of the House and the Senate, and we've done this. In this instance, in this particular amendment, the House expressly considered this matter. They voted with a bipartisan majority to adopt the provision that this amendment is seeking to strike. With all due respect, the distinguished senator from Alabama, who contributed immensely to the bill as ranking member of the committee last Congress, I understood why he opposed this provision when it's controversial and would have had Congress override the PTO. But now the federal court and the PTO have resolved the matter as reflected in the bill, it's not worth delaying enactment of much-needed patent reform legislation that can help create jobs and move the economy forward. Madam President, we will have 3 amendments on the floor today we vote on. This one and the other 2, I would strongly urge senators, Republicans and Democrats, just as the ranking members urge, to vote them down. We have between 600,000 and 700,000 patents that are waiting to be taken care of. They can unleash the genius of our country and put our entrepreneur class to work and create jobs that can let us compete with the rest of the world. Let's not hold it up any longer. We've waited long enough. We debated every bit of this in this body and passed it 95-5. We, on the motion to proceed, over 90 senators voted to proceed. It has passed the House overwhelmingly. It is time to stop trying to throw up roadblocks to this legislation. If somebody doesn't like the legislation, vote against it. But this is a product of years of work. It is the best we're going to have. Let us get it done. Let us unleash the ability, inventive genius of Americans. Let us go forward. We have a patent system that hasn't been updated in over half a century, and yet we're competing with countries around the world that are moving light years ahead of us in this area. Let's catch up. Let's put America first. Let's get this bill passed. I yield the floor.
Madam President.
The senator from Washington.
Madam President, I call up Cantwell Amendment number 595.
The clerk will report.
Senator from Washington, Ms. Cantwell, proposes an amendment numbered 595. On page 119, strike line 21 and all that follows through page 125, line 11, and insert the following.
Madam President, I ask that the reading be dispensed with.
Without objection.
Thank you, Madam President. Simply, my amendment restores Section 18 of the language that was passed out of the United States Senate, so it basically implements the Senate language. Madam President, I come to the floor today and with much respect for my colleagues, Chairman Leahy, who's worked on this legislation for many, many years, and my colleagues on other sides of the aisle who have tried to work on this important legislation and move it forward. I am sure it has been challenging. And I mean no offense to my colleagues about this legislation. It's simply my perspective about where we need to go as a country and how we get there. I'm excited that we live in an information age. In fact, one of the things that I count very fortunate in my life is the fact that this is the age that we live in. I often think that if I lived in the agrarian age, and maybe I would be farming, and that is also of great interest, given the state of Washington's interested in agriculture, or maybe I would live in the industrial age and when new factories were being built, and that would be interesting. But I love the fact that whether you're talking about agriculture, whether you're talking about automotive, whether you're talking about health care, whether you're talking about software, whether you're talking about communications, whether you're talking about space travel, whether you're talking about aviation, we live in an information age where innovation is created every single day. In fact, we are transforming our lives in a much more rapid pace than any other generation because of all that transformation. So I love the fact that the United States has been an innovation leader, and I love the fact that the state of Washington has been an innovation leader. If one thing I pride myself on is representing a state that has continued to pioneer new technology and new innovations. So when I look at this patent bill, I look at whether we are going to help the process in making innovation happen at a faster rate, or more products and services to help us in all of those industries I just mentioned, or whether we're going to gum up the wheels of the patent process. And so, yes, I join my colleagues who've been out here on the Senate floor, like Senator Feinstein and others who debated this issue of changing our patent system to the first to file, which will disadvantage inventors, because first to file will lead to big companies and organizations getting the ability to have patents and to slow down innovation. If you look at what Canada and Europe has done, I don't think anybody in the world market today says, oh my gosh, let's change to the Canadian system because they have created incredible innovation, or let's look to Europe because their first to file has created such innovation. In fact, when Canada switched to this first to file system, it actually slowed down the number of patents filed. So I have that concern about this legislation, but we've had that discussion here on the Senate floor. I know my colleague is going to come to the floor and talk about fee diversion, which is the fact that the Patent Office actually collects money on patents, a very viable way to make the Patent Office effective and efficient, because it could take the money that it collects from these patents and use it to help speed up the process of verifying these patents and awarding them. But the Senate chose good action on this issue and good measure and simply said that the money collected by the Patent Office should stay in the Patent Office budget. But, Madam President, that's not what the House has done. The House has allowed that money to be diverted into other areas of appropriations, and the consequence will be that this patent reform bill will basically be taking the economic engine away from the Patent Office and spreading it out across government. And so the reforms that we would seek in patents to make it a more expeditious process is also going to get slowed down. So, Madam President, I could spend my time here today talking about those two things and my concerns about that, but that's not even really why I'm here this morning. I'm here to talk about how this legislation has a rifle shot earmark in it for a specific industry to try to curtail the validation of a patent by a particular company. That's right. It's an earmark rifle shot to try to say that banks no longer have to pay a royalty to a particular company that has been awarded a patent and has been upheld in court decisions to continue to be paid that royalty. So that's why I'm here this morning. And you would say, well, she's objecting to that earmark. She's objecting to that personal approach to that particular industry giveaway in this bill. Well, actually, Madam President, I'm concerned about that, but what I'm concerned about is the way that they have drafted this language to benefit the big banks of America and screw a little innovator is basically drafted so broadly that I'm worried that other technology companies are going to get swept up in the definition, and their patents are also going to be thrown out as invalid. That's right, Madam President. Every state in the United States could have a company that under this language could now have someone determine that their patent is no longer viable, even though the Patent Office has awarded them a patent. That's right. Companies who have revenue streams from royalties, who are operating their companies, could now have their bank financing, everything pulled out from under them because they no longer have a royalty stream. That's right. Businesses could lay off people. Businesses could shut down, all because we put in broad language in the House version that exacerbates a problem that was in the Senate version to begin with. Now, I could say that, you know, this is all a process and legislation follows a process, but I object to this process, Madam President. I object to that this language that benefits the big banks was never debated in the Committee of Jurisdiction, the Judiciary Committee. It was not debated. It was not voted on. It was not discussed there. It was put into the Manager's Amendment, which was brought to the Senate floor with little or no debate because people wanted to hurry and get the Manager's Amendment adopted. Now, I objected to that process in driving this language because I was concerned about it, sought a colloquy at that point in time and was not able to get one from any of my colleagues, and so opposed this legislation. Well, now this legislation has been made even worse in the House of Representatives by saying that this language, which would nullify patents, that's right, the United States Senate would be participating in nullifying patents that the Patent Office has already given to companies, can now go on for 8 years. 8 years is what the language says when it comes back from the House of Representatives. So, Madam President, all I'm asking my colleagues to do today is go back to the Senate language that you passed. Go back to the Senate language that at least says this earmark that you're giving to the big banks so they can invalidate a patent by a company because you don't like the fact that you have to pay a royalty on check imaging processing to them. I'm sorry that you don't like to pay the royalty, but when somebody innovates and makes a technology, they have the right to charge a royalty. You've been paying that royalty. I'm sorry, big banks, if you don't like paying that royalty anymore. You are making a lot of money, but to try to come to the United States Senate with an earmark rifle shot and X out that competition because you don't want to pay for that technology is not the way the United States Senate should be operating. And the fact that the language is so broad that it will encompass other technologies is what really has me concerned. If all my colleagues want to vote for this special favor for the big banks, go ahead. But the fact that you are going to basically pull us in to having other companies covered under this is a big concern. And the section that I'm concerned about is business method patents, and the term covered business method patents means patents or claims, a method, or corresponding apparatus for performing data processing or other operations. Or other operations. What does or other operations mean? How many companies in America will have their patent challenged because we don't know what or other operations mean? How many? How many inventors will have their technology basically found null and void by the court process or the patent office process because of this confusing language? So, Madam President, I'm here to ask my colleagues to do a simple thing, revert back to the Senate language. It's not a perfect solution. If I had my way, I'd strip the language out altogether. If I had my way, I would have much more clarity and predictability to the patent lawyers and patent office so that the next 3 or 4 years won't be spent in chaos between this change in the patent business method language and the whole process that's going to go on. Instead, we would be moving forward with predictability and certainty. So I ask my colleagues to just help this process. Help this process move forward by going back to the Senate language. I know that my colleagues probably want to hurry and get this process done, but I guarantee you this language with the Senate version can easily go back to the House of Representatives and be passed. What I ask my colleagues to think about is how many companies are also going to get caught in this process by the desire of some to help the big banks get out from under something the courts have already said they don't deserve to get out of. So I hope that we can bring closure to this issue, and I hope that we can move forward on something that gives Americans the idea that people here in Washington, D.C. are standing up for the little guy. We are standing up for inventors. We are standing up for those kind of entrepreneurs, and we are not spending our time putting earmark rifle shot language into legislation to try to assuage large entities that are well on their way of taking care of themselves. So, Madam President, I yield the floor and reserve the balance of my time and hope that if my colleagues have any questions on this language as it relates to their individual states, that they would contact our office and we'd be happy to share information with them. I thank the President and I yield the floor. Madam President, I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka.
The senator from New York.
I ask unanimous consent the quorum be dispensed with.
Without objection.
Thank you, Mr. President, Madam President, and I rise today to urge this body to complete the extensive work that has been done on the Leahy-Smith America Invents Act and send this bill to the President for signature. The America Invents Act has been years in the making. The time has come to get this bill done once and for all. The importance of patent law to our nation has been evident since the founding. The Constitution sets control over patent law as one of the enumerated powers of the Congress. Specifically, it gives the Congress power, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries, unquote. Today, we take an important step towards ensuring that the constitutional mandate of Congress is met as we modernize our patent system. This bill is the first major overhaul of our patent laws literally in decades. My colleagues have spoken at length about the myriad ways the America Invents Act will bring our patent law into the 21st century. What I want to focus on, of course, is jobs. The America Invents Act is fundamentally a jobs bill. Innovation and intellectual property has always been and always will be at the heart of the American economy. By rewarding innovators for inventing newer and better products, we keep America's creative and therefore economic core healthy. Over the last few decades, however, innovation has outpaced our patent system. We have an enormous backlog at the PTO. The result of this backlog is that it is much harder for creators to obtain the property rights they deserve in their inventions. That challenge, in turn, makes it harder for inventions to be marketed and sold, which reduces the incentive to innovate. Eventually, this vicious cycle became poisonous. The American Invents Act cuts this cycle by making our patent system more efficient and reliable, by providing the Patent and Trademark Offices the resource it needs to reduce the backlog of nearly 700,000 patent applications. The bill will encourage the innovation that will create and protect American jobs. In addition, the bill streamlines review of patents to ensure that the poor quality patents can be weeded out through administrative review rather than costly litigation. I'm especially pleased that H.R. 1249 contains the Schumer-Kyle provisions that we originally inserted in the Senate to help cut back on the scourge of business method patents that have been plaguing America's businesses. Business method patents are anathema to the protection that the patent system provides because they apply not to novel products or services, but to abstract and often very common concepts of how to do business. Often, business method patents are issued for practices that have been widespread use for years, such as check imaging or one-click checkout. Imagine trying to patent a one-click checkout long after people have been using it. Because of the nature of the business methods, these practices aren't as easily identifiable by the PTO as prior art, and bad patents are issued. Of course, this problem extends way beyond the financial services industry. It includes all businesses that have financial practices, from community banks to insurance companies to high-tech startups. Section 18, the Schumer-Kyle provision, allows for administrative review of those patents, so businesses acting in good faith do not have to spend the millions of dollars it costs to litigate a business method patent in court. That's why the provision is supported not only by the Financial Services Roundtable and community bankers, but by the Chamber of Commerce, the National Retail Foundation, and in my home state by the Partnership for a Greater New York. And I'd like to ask unanimous consent, Madam President, to put letters of support of Section 18 from all these groups in the record.
Without objection.
Okay. A patent holder who has a patent whose patent is solid has nothing to fear from a Section 18 review. Indeed, a good patent will come out of such a review strengthened and validated. The only people who have any cause to be concerned about Section 18 are those who have patents that shouldn't be influenced in the first place, and who are hoping to make a lot of money suing legitimate businesses with these not legitimate patents. And to them I say the scam should stop. In fact, 56% of business patent lawsuits come in one court in the Eastern District of Texas. Why do they all go to one court? Not because of just coincidence. Why do people far and wide seek this? Because they know that court will give them favorable proceedings, and many of the businesses who are sued illegitimately say, instead of millions of dollars of discovery and everything else in a court that I believe I can't get a fair trial in, I'll settle. That shouldn't happen. And that's what our amendment stops to do, simply by providing review before costly litigation goes on and on and on. Now, my good friend and colleague, Senator Cantwell, has offered an amendment that would change the Section 18 language to return to what the Senate originally passed in last March. Essentially, Senator Cantwell is asking the Senate to return to the original Schumer-Kyle language. Of course, I don't have an inherent problem with the original Schumer-Kyle language. However, while I might ordinarily be inclined to push my own version of an amendment, I have to acknowledge that the House made some significant improvements in Section 18. First, H.R. 1289 extends the traditional review program of Section 18 from 4 to 8 years in duration. This change was made to accommodate concerns that 4 years was short enough that bad actors would just wait out the program before bringing their business method patent suits. The lying in wait strategy would be possible because Section 18, under this amendment, because Section 18 only allows transitional review proceedings to be initiated by those who are facing lawsuits. On a 20-year patent, it's not hard to wait 4 years to file suit and therefore avoid a scrutiny under a Section 18 review. It would be much harder, however, to employ such an evasive maneuver under a program that lasts 8 years. Second, the amendment changes the definition of business method patents to eliminate the House clarification that Section 18 goes beyond a mere class of 705 patents. Originally, Class 705 patents, Originally, Class 705 was used as the template for the definition of a business method patent in Section 18. However, after the bill passed the Senate, it became clear that some offending business method patents are issued in other sections. So the House bill changes the definition only slightly so that it does not track the Class 705 language. Finally, the amendment limits who can take advantage of the Section 18 program by eliminating access to the program by privies of those who are sued. Specifically, H.R. 1249 allows parties who have shared interest with a sued party to bring a Section 18 proceeding, and the Cantwell Amendment would eliminate that accommodation. All of the House changes to Section 18 of the Senate bill are positive, and I believe we should keep them. But to my colleagues, I would say this, in closing, the changes that Senator Cantwell are proposing do not get to the core of the bill, and the most profound effect they would have is to delay passage of the bill by requiring it to be sent back to the House, which is something, of course, that we're all having to deal with on all three of the amendments that are coming up. I urge my colleagues to remember that this bill and the 200,000 jobs it would create are too important to delay it even another day because of minor changes to the legislation. I would urge my colleagues to vote against my good friend Maria Cantwell's amendment and move the bill forward. With that, Madam President, I yield the floor.